third appeal in the matter of Optis Cellular Technology and others, and Apple Retail UK Ltd.
Mr. Taylor. Please the court. Housekeeping. I need to enter a clarification on one of the issues being debated yesterday about the experts and their reports. Ms. Guttridge has understandably been following this on the live stream, and the accurate position is this. She was not instructed as to the basis for expressing the royalty rate. Wants to make that clear. She said in her first report, and this is a quote, "Consistent with Apple's pleadings, I express royalty rates as $1 per unit." And then she worked on that basis. She has pointed out, reminded us, however, that she did express royalty rates as a percentage of Apple's weighted average selling prices over the license term in the appendices to her reports. What she had not done is the so-called simple unpacking, making that allowance for the past, spreading the license amount over, I think it was 5 years for the past, as well as the future term, which Mr. Bizant had done. And that was the point in relation to which Mr. Speck said to the court on day one of the trial, and you'll recall this because Mr. Speck took you to it in the judgment, it's the middle of page 267, "They have not done it, my lord, and that is the problem." And the judge agreed with that, that was his concern, and that was then what her team went on to do. Day one of the trial was the 13th of June. They produced the material on the 28th of June. That then triggered the strong objection to its admissibility on Optis's side, and ultimately to the expression of frustration by the judge in his judgment. And just to remind you of that, if you go to the judgment, what he said about this, you see from the top of page 270 in Roman 5. So this is now after the trial, which was June. In a letter in October, Optis is maintaining its substantive objections to, and that was what it was about. It was the provision of the material on this different basis. And you'll see what the judge says about it there, and also in Romans 6, a reference to Mr. Bizant not having done something that he wanted, and that was about calculating implied lump sums on the running royalty licenses. So not the Apple licenses, which were already, you had actual lump sums, but the running royalty licenses. That connects to the debate we had yesterday about why the judge would have been interested in that sort of information. The position for the other expert, Mr. Bizant, is that he presented only ad valorem rates in the reports, and then the judge made his request, and he did provide $1 per unit rates in detail, as Mr. Speck told you. But also, and in fairness to Mr. Bizant, he does not say in his reports that he was instructed to approach the unpacking in that way. If you go to page 393 of the judgment, and this is therefore also in fairness to him, and you look at Roman 1 in paragraph 314, you'll see the judge begins, "Thus Mr. Bizant was instructed," underlined, to the way he should approach valuation. But then 4 or 5 lines down, he says, "Although Mr. Bizant does not say in his report that he was instructed to approach the question of unpacking in this way, that must have been the case. So what you have is an inference from the judge.
And I take it that that was never put to the witness.
That was, I don't believe so, and again, we'll absolutely double check.
That was what I understand Mr. Speck to say.
Yes. Yeah.
And that's one of his complaints, that it's an attack on the witness, which is entirely unjustified in the circumstances where the witness has never had the opportunity to answer that.
Yes. My Lord.
And I think you're accepting that that's a correct statement.
I am subject to us going back and double checking the transcript on that. I want to get this absolutely right. And may I say also in relation to the questions you raised about this yesterday, we're checking that and you will get the answers that you want.
Thank you.
It might not be today, it might be for Monday morning. So that's the first point, and I need to do that for obvious reasons. Second point is that we discussed yesterday the question of how the parties were presenting their cases at the trial and whether this issue of the weighting of the comparables by their stack share was a central part of the parties' positions or not. And I showed you yesterday the shape of Optis's pleaded case, and it was pointed out to me, well, this is relying on their comparables. Lord Justice Birss made a fair point. I should also show you the way that Apple was putting its comparables case for completeness. That is core 3 at tab 3. And if you go in tab 3 to page 61, some of this material will now be becoming more familiar to the court. So you see at the top, it's all in blue again, so I'll be careful, but this is the table of the Apple comparables that they were relying on. You can see the in B, the Guttridge unpacked rates, and look on the right-hand side at D, there's the implied rate for the PO portfolio. And there, at that point, before the Ericsson licensing, it was the higher number of 0.6.
Yes.
Well, that number is not in
not
blue.
blue.
Yeah. It's not in blue.
My lord, I was over cautious as to what my learned friend was to do that. And I do apologise, your lordship is absolutely right.
It's nice that your junior has no faith in you.
It's extremely helpful to have a minder behind you. And this goes on. But anyway, one sees for Ericsson, I'm not going to read it out, a familiar figure. And if you read down that last row, that last column, you do see the numbers at least scaled to that slightly different, slightly larger portfolio there.
And presumably the way this scaling is done, if it's scaled to Optis's stack share, you must also, as part of that scaling, take into account the licensor's stack share in order to scale it.
Yes. Yes.
You have to take both numbers and put them together.
Yes.
So.
That's right. When we say Optis's stack share again, there's the number I can't read out at the top, that percentage. So at that point, that included what we've been calling the ex-Ericsson patterns, which then don't become part of the subject portfolio. So both sides have engaged with these metrics, and you've obviously heard in the course of this appeal, Mr. Speck drawing attention to one aspect of this in support of the point that he wanted to make. And if you please look at the paragraphs below 45 and 46, you see how Apple was framing its case in the pleadings on how to use these comparables. So at 45, they begin by saying that there's a range here, the first 3 lines, and it's identified. A little bit further down in blue, there's the point that a lot of, well, you'll see what that point is, that in terms of what the portfolio related to, what sort of patents were in there. And at B, there's the point which is not thankfully in blue, that the Apple sales volumes used by Miss Guttridge are forward-looking only and they don't seek to account that at all for the past releases. And within that range, the way that it was done was more impressionistic. At paragraph 46, Apple said, Miss Guttridge has identified a certain number of the comparables that exhibit certain consistence, and you can read how it was put. And then, having looked at those ones which they said had certain features that the court may want to take into account when it was weighing up comparables, they proposed a different range at the end of 46. Again, nothing to do with the weighting of stack shares in the way that the case was put. Paragraph 47, below that, is concerned with exposing the implications in cash terms of Optis's ad valorem asks on the selling prices of Apple devices, which are well known to be at a higher level than the average. Paragraph 48, that is concerned with how Optis's asks from Apple for the portfolio compare with the license rates that were being paid by Apple to very major global licensing entities with large patent portfolios. That was the thrust of the case made below. Yesterday, the court canvassed with me, understandably, what this court has to work with at the end of the day, yourselves, if ultimately you were not to accept that the judge's approach that he took was a reasonable approach open to him to take, which I will be arguing against. What all of this shows in the case that was made, and in relation to what you've heard in the argument so far in this court, including from Mr. Speck, in relation to those tables that we've gone into in some detail, is that this court has available to it the unpacked rates, certainly on the free release basis, I'll come back to the others in due course, of both Miss Guttridge and Mr. Bizant. This court has already appreciated that to a large extent they align, that there are some differences, and my Lord Justice Birss raised one question about that. So that is all by way of saying that if there is which one hopes you will, we hope you will not get into this position, but that were you to reach this position and decide that what the judge did was not a reasonable approach open to him, it is not a question of that Google license or remittal and start again. That is all I wanted to say by way of picking up from points of yesterday. And with that, I will turn to what I believe is the fifth headline point I was going to make. I did say yesterday, towards the end of the hearing, that the judge's approach to the Frand question was influenced by certain key features of the evidence and the facts in this case. He came to this area, which is rapidly developing, relatively new, and he was responsive to the evidence he heard. And those key features concern a number of things that I'm just going to spend a moment on, drawing to your Lordship's attention. First, there was a significant amount of evidence and debate about the quality of the Optis portfolio. Ultimately, the conclusion of the court was that it was a below-average patent portfolio, or in some respects, at most average. And the question is what implications that had for what the judge did, which we shall look at. The second key feature was the direct evidence that he received about the course of the negotiations over the patent portfolio between the SEP owner and the licensee in this case, Optis and Apple, and what light that cast on Apple's pattern of conduct in licensing negotiations, because you actually have here a small licensor.
Well, there's two separate questions there, and I'm anxious to disentangle them.
Yes.
As you rightly say, one of the issues that's raised certainly by Optis is the impact of what they claim was historically Apple's negotiating stance, and they claim that it was what Mr. Speck describes as a blueprint for holdout. So that's plainly, firmly in issue.
Yes.
But then there is the separate question of the negotiations between Optis and Apple themselves for a license, which obviously never reached fruition because that's why we're here.
Yeah.
Now, I want to be very clear as to what your side's position is on that second question, because if I understood Mr. Speck correctly, he's not arguing at any rate in this court that that is of any relevance whatsoever. Save insofar as he says it's just consistent with the pattern of behaviour we say he says exists elsewhere, but he's not trying to make any independent point about willingness as between these parties with respect to this licence. And my question to you is, are you trying to make any independent point with regard to willingness as between these parties with respect to this licence?
Yes. Your Lordship's absolutely right in the distinction that you make, and agree entirely with the way you've put it. What I am saying is that it was a feature of the trial in which the judge was able to see these aspects of the negotiating dynamic between these parties and to place it in context as to what it revealed about Apple's modus operandi more generally. In terms of how that relates to the judgment itself,
I'm sorry, you haven't answered my question.
I'm sorry. I am.
You seem to be saying, yes, you have a positive case that the willingness of these parties is somehow germane to the determination of FRAND. And I'm waiting to find out what that is.
It's that, and I'll develop it in a moment and see what your Lordship makes of it, that the court saw direct evidence of the negotiations here, and it took a view on how not only Optis but also Apple conducted itself. And our case is that that was relevant to the conclusion that he drew at the end of the judgment, round paragraph 481, that Apple negotiated properly, not just here, but he also says, generally speaking, Apple, in its negotiations with the parties who Mr. Speck said were the victims of holdout, also there.
I'm sorry, I'm still struggling to understand this. The relevance of Mr. Speck's argument, whether it's right or wrong, is that it goes to the assessment of the Apple comparables and their reliability, or possibly comparability, but certainly their reliability, for the purposes of arriving at a FRAND determination in this case. But because there never was ex hypothesi any license as between Apple and Optis, which is why we're here, there is no financial analysis to be undertaken to which that could be relevant. There is no comparable because there is no license, that's why we're here.
No.
So the question comes back, is it suggested that the negotiations between parties is of any relevance? And the only conceivable relevance I can see at the moment is that somehow willingness feeds into the FRAND determination. At the moment, the view I take on that is that the answer to that, which this court gave in Interdigital, which was a firm no, is equally applicable here.
Yeah.
And you seem to be presaging an argument that what we said in Interdigital is wrong, and I'm waiting to find out what that argument is.
Right. I'm not directly addressing a comparison with the Interdigital case, but to put simply what I'm saying here, I now understand, I hope I understand your Lordship's point a little better. We're not saying that anything that emerged as the output from these negotiations between Apple on the one hand and Optis on the other gives you any handle on the FRAND question. What I am responding to is the thrust of the argument from Optis, which was that the way in which Apple approaches negotiations with its blueprint for holdout is a systematic approach that it has taken and continues to take, according to Optis. And their case was to say that in view of the behaviour in negotiations, which Mr. Speck relies on, and that includes not merely the behaviour about which there was extensive cross-examination, but historic references to certain slides, internal slides of Apple, so that one should make an inference, he says, from purpose as to their modus operandi, that you should first of all make the finding, which the judge did not, that their behaviour in negotiations was oppressive and calculated to lead to sub-FRAND rates. And secondly, and closely relatedly, that the outcome, therefore, a word I'm going to come back to in a different context, that therefore, if they did these things in its negotiations with the counterparties, which were the comparables, Ericsson, Nokia, InterDigital, and so forth, therefore, this court can and should assume what the judge below did not, that the rates achieved in those cases, in the comparables cases, were sub-FRAND rates.
So just to be clear, you say what went on as between Apple and Optis gives you insight into what significance you should attach to the Apple comparables, because you could expect similar behaviour with those transactions.
Yes, I do. And I say in relation to my Lord Justice Arnold's point, which I am grateful for and now fully understand, I hope, that this is in part responsive to the way that the case was developed below by Optis, which is to say there is a pattern of behaviour here, systematic pattern of behaviour in the way that they deal with counterparties in licensing generally. And from that, we wish you to assume, make the finding, that all these comparables are unsafe because the outcome will have been sub-FRAND for that reason. And I am making the point that both, first of all, implicitly, because it was a major part of the trial below and a major part of the judgment, actually, that the question of negotiations between these parties was assessed and there was direct witness and documentary evidence. And secondly, there was a bridge in the judgment itself, because the something you may not have picked up, but the licensing by Optis was accompanied by, and I'll have to try to recall the precise link between the two entities, licensing by another entity which is called Innovius, which at a certain point was a licensing negotiation in relation to many of the same patents. And what the judge does do in the judgment, I'll come to this in a moment, is he talks about Apple's behaviour and how Apple generally behaves. And then he says a typical way, his example of how Apple behaves, is he gives this Innovius example as his representative case. So there is a link made there. So that's the second point, and I shall not labour it, but I will want to show the court as quickly as I can. Yeah. I'm sorry, that's Mr. Nicholson reminding me. I haven't made this as clear, perhaps, as I should have done, that in the Optis case, unlike in the other cases, which were the subject of cross-examination by Mr. Speck of the negotiator witnesses on Apple's side, and there were three of them, the principal one being this lady, Miss Muse, the second one being a Mr. Brian Ankenbrand, the third one being a Mr. David Rockower. That cross-examination was very extensive, and it was conducted by reference to disclosure documents of the negotiations between the parties. And Mr. Speck very thoroughly and skillfully cross-examined our witnesses at length by reference to that material. That is what the judge saw and heard. Mr. Nicholson reminds me that in relation to the Optis case, which did not result in a number, the judge had the advantage of the witnesses on both sides of the table giving live evidence, as well as the documentary material. And so we had a particularly detailed picture in that case. I'll come to that. The third feature is that Apple had, as the court is now well aware, an extensive stock of comparable licenses to roughly half of the whole 4G SEP stack. And the evidence was that it cared greatly, and continues to do so, about the aggregate royalty burden it faces when it is paying for access to the standard, and how this fits with the regulatory pronouncements about the importance of the aggregate burden in this sort of case. So with that introduction, I'll take you to those points.
Well, that's a very important point, but I'm struggling to understand
Yeah.
why it's different for Apple than any other implementer. All implementers need licenses for the whole stack. So for any implementer, the aggregate burden is a concern.
Now, my lord, that's correct. Of course it is correct. In practice, Apple does find itself, for quite obvious reasons, a major target of licensing demands by SEP owners in this field. And I cannot speak to what the situation is with other implementers generally, but this particular...
I think you'll find that parties like Lenovo say that they're targeted pretty heavily as well.
Yes. Well, in that case...
And Huawei, just to give a couple of random examples.
No, my lord, that's a point well taken. And in that regard, then I'm not distinguishing Apple from implementers of that kind. But then in common with them, but particularly because one sees it here in the case of Apple, they are very concerned about how any individual licensor's demand, I was going to use the phrase stacks up, but and perhaps I will, it's obviously pertinent in both senses, what it means. And it has an eye on matters from that point of view as its general approach. That was indeed, as you will have seen from the judgment, the essence, and I'll show you the paragraphs again, of the Apple methodology whenever a SEP licensor knocks on its door, and the approach that it adopts. So if I may, I'll turn to that first issue, which is the dubious quality of the Optis portfolio and the findings of the court. This court's aware that the appellant is a non-practicing entity that was asserting a small portfolio of SEPs that was not entirely spun off from other major licensors, of which there were, can I say the entities? Yes. Of which there were four, Ericsson, Panasonic, LG and Samsung. I say not entirely spun off because they continued to have a stake, financial stake, in the deals that this entity then strike. Now, if you go to page 301 of the judgment, please. Under the heading on that page, evidence from Optis's witnesses, halfway down, you see that Optis consistently claims in its negotiations, as it did at the trial, that the Optis portfolio, paragraph 148, was above average in quality, high quality. And by that term quality, what was meant at least the rate of patent validity and essentiality in relation to the 4G standard. The evidence showed the court that the package of patents acquired by this entity included some so-called litigation grade patents intended to be deployed in the courts, and then a long tail of patents, many of which were weak. The judgment records specifically that there was a pyramid approach to quality when assembling the portfolio. If you go to the judgment on page 320, and you look at the foot of the page, paragraph 177, the last 5 lines, the patents that were placed in the portfolio comprised some litigation grade patents intended to make good any claim in the courts, whether on validity or essentiality, some to read onto specifications to enrich the quality or apparent quality of the pool, and some make weights. And then paragraph 178, one document considers what patents had been and needed to be put into the portfolio by Ericsson and Panasonic and refers to a pyramid concept quality. The other says it's our belief that the amendments made result in a more pyramid-shaped portfolio from a quality perspective. And this was in line with a significant aspect of the evidence that was given by Optis's own licensing expert at the trial, Mr. Starzik. He was cross-examined actually by Mr. Nicholson on an analogy that he gave between the patent portfolio, if you're in these negotiations, and a barrel of fish for sale. And you heard Mr. Speck, it may have escaped, he referred to this fish on day 1 of the hearing. I will clarify it. It's helpful in understanding the nature of the product which is being valued in a FRAND case and the way that negotiations take place. The idea is that a barrel of fish is for sale and the fish on the top of the barrel smell good and fresh. It's not possible for the buyer to assess the freshness of all the fish in the barrel, but the buyer does need to get a sense of the quality of what he or she is paying for overall. So what do? They do what my Lord Justice Arnold referred to in the address by Mr. Speck. They sample the fish in the barrel until it starts to become apparent where the fish smell less fresh.
It's a vivid metaphor, but why is this case any different from any other? Because this is what all set portfolio owners do. They have a range of patents, some of them are strong, some of them are weak, and this is what all implementers do. They have to take a view on the strength of the portfolio as a whole. And the only rational way to do that is sampling.
Yes, exactly. My Lord, I'm not deviating from that in the least. This is the evidence that was given by the licensing expert about how things happen generally in the industry. And it was in the context of that evidence, which I'm pleased to say does accord with your Lordship's knowledge and experience in this field, that this judge in this case heard how things are done and what the value of a product typically offered to a buyer is. And it was in the context of that that he made the comments and the findings that I've referred to about the pyramid shape of the portfolio. And if you go to page 321, paragraph 179, Roman 2, you see just, it's near the bottom of the page, the last 4 lines of that about the pyramid documents. He says, I can conclude, underlined, that there was a structure to the portfolio, and I'm entitled to infer that the structure would have been on efficient and cost-effective lines. In other words, minimum spend for maximum revenue. And then if you look over to the facing page, 322, you see paragraph 181. I conclude there's no evidential basis for suggesting the Optis portfolio was anything other than an assertion portfolio constructed according to conventionally efficient means, where the original owners, in order to leverage their portfolio, split or divide it so that a portion could be enforced by another party, here Optis, so that additional rents or returns from the pool could be generated. And then he makes the point, I can see is now not confidential, it must not be forgotten that the transferors retain an interest in the fees that are generated to third parties. This is the context for the judge's actual determination in this case, that if anything...
The conclusion in 182 is he proceeds on the basis that Optis's portfolio was average.
He does, yes he does. There are other references in this, now I'll just go to one in particular, where he expresses it in a slightly different way. But we say below average on one metric, average on another, and as your lordship rightly says, he says overall, I'm going to say it's at most average. If you go to page 319, just back a couple of pages, and look at paragraph 171, the specific finding is additional evidence regarding the quality of Optis's portfolio derived from sources other than the PA consulting is, for the reasons I've given, not helpful to inquire before me. If anything, this evidence points in the direction of Optis's portfolio being average in terms of validity and below average in terms of essentiality.
So Mr. Stone, I want to be clear what your submission is, because as I read this, let me tell you, that's the judge in the course of analysing various different sources of evidence.
Yes.
Concluding that he says that source, which is stuff other than PA consulting, which he doesn't think is helpful, but if evidence, it would point in the direction of below average or average. But then his conclusion that you showed us ultimately is to proceed on the basis that the portfolio is average.
Yes. Stay with that.
Yep.
But then let's see what implications that then has for him in the approach to the Frand question that he takes. And for that, you go to page 285. I'm sorry, this is not proceeding in a linear fashion. In the judgment, but if you go back to page 285, you've got paragraph 108, introduction. Optis placed a great deal of stress on the importance of not accepting Apple's denominator when considering stack shares. This was the declared essential denominator. Apple's denominator was a big number, and Optis's contention was that it was too big and unfairly prejudiced those SEP owners that have above average quality portfolios. It was contending it fitted into that group. Then the judge explains that in a way that I'm not going to go into in detail.
I'm struggling to understand where you're going with this. You make the point, which is well made, that Optis had a case that they had an above average quality of portfolio, and that was firmly rejected by the judge.
Yes.
But where further does it go than that? I mean, that's a point they advanced, they lost on it, and there's no challenge in this court.
There's no challenge in this court. It's the point I'm just about to make, which is that a key part of the approach criticised in this court, which the judge adopted, was that this part of it too should be looked at. What he does is, he just to cut to the chase on this, he takes mainly the Apple licenses. He works out what the implied total royalty burden will be from each one, and he got an average figure. And then he says, so that's the pie, what percentage of that is attributable to Optis? And when he's doing that last bit of the sum, he applies a percentage. this part of the judgment, and you have to look at paragraph 109 for this point, shows why the judge was reasonable in saying I'm going to apply the percentage that comes out of this declared essential data in order to work out how important the Optis portfolio is. You'll see that for yourselves in paragraph 109. Now that point 2 is not specifically contested, but this is to illuminate how the judge was approaching his FRAND determination, and that was one important part of it. The judge, the judge also made a more general methodological observation about how you assess relative quality of set portfolios held by different licensors based on the evidence that he received in this trial. And that you should look at too. It's on page 449. At paragraph 409 at the top. And this is again, I hope, a point that will be uncontroversial in this court. But he says it's not possible in these sorts of cases to make any kind of more generalised assessment of portfolio quality. I've considered whether it can be said that the Optis portfolio is above average quality, as Optis contended. I've concluded it's unsustainable, and if anything, it was below average in terms of quality. I'm just trying to pick up these references so you see the overall picture, because of the way in which it seems to have been structured. But stepping back, it seems to me that even the conclusion that it was of below average quality is one I should be wary of drawing. Although I've been able to consider the portfolio in some detail, I've no material before me to reach any particular conclusion about the portfolio of SEPs comprising the rest of the stack. I've no way of knowing whether, set against the Optis portfolio, these collections of SEPs are better or worse in terms of validity, essentiality. By importance, I think he means technical merit, which was the third metric we were using, than those comprising the portfolio. It therefore seems to me, this is the important sentence, that I should regard the SEPs comprising the stack as essentially homogeneous when grouped together in a portfolio of any substance. So he says, if you're doing a FRAND determination in my position, this is how I have to look at these elements. And the extension of the reasoning is over the page at 450, paragraph 413, where he says, not only is it not possible individually to review the content and contribution of each set within a portfolio, this is an inappropriate approach. In my judgment, what is being valued or priced is access to the standard, cellular connectivity to the relevant standard, essentially, or the right to use it without infringing. It's the SEP owner's contribution to this access or right of use that an implementer is paying for. The benefits of access to the standard have already been sufficiently rehearsed and they're obvious. You can offer connectivity. Where a SEP owner holds a part...
It's a bit of a limited statement to say that they enable inter-handset connectivity. That's not the only thing they do. But
I'm sorry?
it's not just inter-handset connectivity. Does it matter?
No.
It probably doesn't matter.
No, and my lord, there was also at the trial, and it's not a feature of this appeal, quite a healthy debate too about the extent to which you can say that other features in what an Apple iPhone does are sufficiently connected with cellular connectivity to mean that some part of that value should be given to the to the SEP owner, and there was economic evidence on that.
Sorry, I
Example.
forgive me.
No, but that is a point I'm just going to come to in a moment in a slightly different context. The judge then went on, where a SEP owner owns a part of the stack that enables use of the standard, part of the total stack price should be payable to that SEP owner, irrespective of the validity and essentiality or importance of the patents owned. and here I think he must mean looking at it on a granular individual level, because the Etsy process for creation of the standard works by reference to declaration. What's being bought and sold is not a bundle of intellectual property rights, but an ability to use the standard. Now, for our part, we do carp to some extent with that last sentence. It's obviously payment for a bundle of intellectual property rights as well. However, the judge's essential point, the thrust of which is not contested in this appeal, is that it makes sense to look at the matter in a broad sense, that you're paying essentially for access to the standard, and each SEP owner who has patents relevant to that with their portfolio should get a piece of it.
Just as a matter of legal analysis, to my mind, would this be fair? I don't dispute what's said here, and particularly not making with the cavil that you mentioned yourself, Mr.
Yeah.
To my mind, these statements are appropriate and accurate when viewed as being what a willing licensor and a willing licensee would do. They're not something extra. It's not some legal principle that says this is the case. This is a manifestation of just what willing licensors and willing licensees in this context would do. Is that fair?
That is not only fair, we wholeheartedly embrace that. Because to come back to a point that my Lord Justice Newey was making when I began about the particular features of this sort of case compared to valuation exercises in other areas of the law, there is a particular emphasis here on the overall position. And when you are bargaining, having a sense of proportion of how much of the stack is at stake here is an important feature, as opposed to simply, well, there is a particular close comparable, I'm going to do a bilateral exercise. Keeping in mind the bigger picture is something which the evidence in this case showed is something that needs to be kept in mind here. I'm now, so having just thought of this, so please excuse me, I'm going to do something that no advocate should ever do, just think of an analogy for you to just shoot me down on immediately.
Oh dear.
So I do
Mr.
apologise.
Nicholson's springing, ready to spring.
He won't look. He won't be the only one. If you take valuing rental for a property, something one might say, well, how much does the same property go for in other cases? How much has it gone for historically? How much do different properties in the same area with similar characteristics go for? And this area, at least someone coming relatively new to it, appears to be, in an important way, quite different. And if you have in mind, for example, so this is drawing partly on and adapting something from personal experience. If you imagine an arrangement between the British state and Chinese government about hosting 500 Chinese judges coming on a summer program to the United Kingdom and needing accommodation in London for a period of months, something of that kind. And the deal is on the basis that there needs to be some kind of overall picture on what the budget will be for this exercise. And within that budget, the question of accommodation of the visitors takes place. And although there is certainly going to be an aspect, if there needs to be a decision on how much should be paid for individual accommodation, if that needs to be decreed or resolved by a decision maker, there is also a need to look at the size of the overall budget and seeing that in each case it should all fit within it and that there should be some kind of proportionality observed. Now, I'm fully aware of all the imperfections of what I've just said as an analogy, but merely to try to illustrate that in a way this feature with the wider picture and with an idiosyncratic price regulation element to it perhaps makes it rather different from some other cases of valuation exercises in other areas of the law. In this case, each SEP owner is the monopoly gatekeeper, essentially, of a proportion of the standard. And the rule is it should have a fair, reasonable and non-discriminatory rate given for its proportion of the standard. So I say it's a species of price regulation. That is the way in which this judge is essentially approaching the matter in the paragraphs that I've referred you to. And this particular perspective is not an issue questioned by Optis in this appeal. It also fitted what the judge pronounced with the, coming back to my Lord Justice Birss's point, with a perspective that was given by the Apple negotiator witness, the main witness, Miss Muse, at the trial, under cross-examination from Mr. Speck, which the judge specifically sets out in his judgment. If you go to page 345, paragraph 211, I don't think you've actually had your attention specifically drawn to it. It's the last box on that page, Miss Muse's answer. Mr. Speck cross-examining her about the proposition that Apple disagrees that there should be essentially an ad valorem approach, a royalty rate linked to the selling price of the handset. And if you read her answer, she says, our view of a standard is essentially, think of it as a plug. There's lots of things that could be attached to the plug. It's very simple. Of course, those standards are very complex, but you're essentially plugging into a cellular network. You're capturing the value of the entire device, value and innovation that's from Apple, from many, many other suppliers of Apple, when you tax the end user at an ad valorem rate, which is just a proportion of the selling price. So that's how it's all tied up. And the point that I will make is that given this analytical framework, this is how the judge thought of his valuation exercise, coupled with the finding that the Optis portfolio was at best of average quality, that also helps to explain why there was no reason for the court to regard Optis's licenses to its counterparties, which, leaving aside the one, the Google, which was itself a small license in ways that I went over yesterday, as being inherently more important material for his Frand valuation exercise as he saw it, when you're trying to find what's the right rate for a license to Apple in this case. In the circumstances of the present case, where almost all the SEP owners' licenses were explicitly found, and it's not disputed, to be unreliable comparables, it made sense, in my submission, for the judge to base the valuation on the information he had before him about licenses from other licensors, covering roughly half of the stack. And that is what he went on to do. And then the two further other findings that I said I'd refer to concern the nature of Optis's dealings with its counterparties in the Frand negotiations, and the nature, in particular, of Optis's dealings with Apple in the Frand negotiations leading to this litigation, for the point of relevance that I've explained. And I'll deal with this very briefly. On the first point, if you go back to page 334 of the judgment, at little Roman 2, this is under the heading on the previous page, hallmarks of Optis's approach to the royalty negotiation, what it did. You see it too, considerable reliance after hand down of the judgment in Unwired Planet, first instance, on various rates tied to and seeking to leverage the judgment of Mr. Justice Birss then was, and referring to it as the court adjudicated rate. And then at 3, further leveraging by favourable comparisons between the quality of the portfolio before Mr. Justice Birss then was and the quality of this one too. And finally, if you go forward to page 444, Roman 4 at the top. I'm skipping out the detailed analysis of him looking at the individual cases. He says the question is why Optis would bother with small counterparties like these. The revenue was trifling, in some cases may even have been dwarfed by the transaction costs. To Optis, although Mr. Blasius denied it when it was put to him, it's difficult to avoid the conclusion that they weren't dealing with the small counterparties for the revenue, but because of the licenses would produce comparables to assist in this litigation. So essentially, it was a pattern of conduct leading to approaching Apple several years after they themselves become the owners of the portfolio. The remaining Optis comparable party was Google, and I've made the point about the value being extracted there and where that sits in relation to the costs of FRAND litigation. I shan't take further time up on that. On the second point, which concerned Optis's dealings with Apple, if you go to page 418, and look at paragraph 354 under the heading My Conclusions. Optis's approach to negotiation was inept. It's difficult to escape the sense that the offers were no more than a series of demands for money, not underpinned by any particular effort in persuading the purchaser the price represented proper value. And I shan't read all of that out at length, but if I would invite you just to read paragraph 354 for yourselves. That's 1 and 2. 2 ends, by the way, with a potentially significant conclusion in this appeal. It will relate to a later matter. I regard the failure to achieve an outcome.
You've pointed us to a finding by the judge that Optis were bad negotiators. What's the relevance of that?
It's the link to what I'm coming on. Well, it's twofold, my lord. First of all, it's the support for the judge's finding in relation to what he says about this particular licensor, the portfolio it was asserting, and so forth. But more particularly, it's in relation to the point I was debating with you earlier, which really, it was part of the context for his conclusions about the dynamic between Apple and Optis when they were negotiating as well. It's relevant to the question, in short, whether, as Mr. Speck would have it, Apple is an inveterate holder-outer which systematically pressurizes other parties into sub-FRAND.
I'm baffled by that submission. How does the fact that the judge found that Optis are bad negotiators, in the sense of incompetent, shed any light at all on Apple's pattern of conduct?
The link, my lord, is this, that, and I'll take you to the relevant paragraph right now, is that in the way in which this licensor conducted itself in relation to Apple too, there was a similar approach on the one side of presenting an apparently random series of increasing demands for money, and the judge approaches that and places it in the context of how Apple on the other side was conducting itself in relation to that licensor, from which one can draw conclusions about Apple's systematic behaviour and its nature of negotiating in FRAND cases.
Yeah.
Mr. Nicholson underlines the point I will develop in a slightly different context later, which is the judge finds at the end of, I think it was Roman 2 there, that the reason for the breakdown here was, in material part, it was Optis's fault. On page 426, you come to the point to follow my Lord Justice Arnold's question, because the judge hears a great deal of evidence and he reads the documentation. There is the cross-examination. And he says at 356 on page 426, and the second sentence, aside from expressing my conclusion that Apple did engage with Optis and negotiated in good faith.
Yes, but look at what he says in the first sentence, because this is the point I've been putting to you, and I'm still struggling to understand your position on it. He says it's a curious feature of both sides' cases in this litigation. They are required to reach conclusions about each side's conduct in negotiations that ultimately found it.
Yes.
And the court, this court in Interdigital, said it's irrelevant because the only question is what is frowned.
Yeah.
And the negotiations in terms of willingness on either side and whether they're good negotiations or bad negotiations is utterly irrelevant to that.
I agree. And we don't demur from that. I'm making a different and therefore, in a sense, more limited point that this material is relevant for the reason that I was mentioning earlier, with this conclusion that what the judge has seen when he has reviewed the evidence about what happened here is that a party, Apple, which is accused on the one side of behaving according to a blueprint in all these cases, which leads to depressed sub-fran rates. He sees here, as he says in the third line of 356, that Apple did engage with Optis and negotiated in good faith. My submission is that this will feed into and support the conclusion that I'm going to show you that he makes, where he rejects the suggestion that he needs to dismiss the Apple comparables as unreliable because Apple will have had the whip hand and will have behaved in a particular way, leading to sub-fran rates in the case of the comparables. So that, my lords, it's the only point I'm making there, but it's a point which I say is of some significance because the question of the sustainability of the judge's conclusion about Apple is one of the issues before this court. I mean, essentially, he made a finding on the facts. The nature of the appeal must be, analytically, that Mr. Speck is saying it's not a conclusion that a reasonable judge could have come to. And as I understand it, the material that he showed when he ran through his closing submissions on this and so forth was an attempt to show you that for those reasons, this was not a conclusion open to the judge that a reasonable judge could have reached. And the point I've just made is relevant to that proposition. The second area is the distinctive characteristics of Apple's business and the implications of that. There were a number of characteristics of Apple's business model that were established on the evidence which fed into the approach that was adopted by the judge. The first is something we've sufficiently covered, which is that Apple's devices are they're unusual. They're particularly highly priced. They sell in large volumes. That was explored in the cross-examination of the witness, and I showed you one part of that. At the time these proceedings were commenced, February 2019, this was a pure, unvarnished ad valorem demand by the SEP owner. It was 0.41% of the selling price for every Apple device sold in a major market. There was then an amendment to their statement, position statement in March 2022, a few months before the trial. And then they said it was an ad valorem rate of 0.22% for the major markets. And they proposed a cap, which I'm not allowed to refer to. And then later in Optis's expert accountant report for trial, as we discussed briefly yesterday, the expert also unpacks the Apple comparables. This is Optis's expert, Mr. Bezant, on the basis of the ad valorem structure which Optis was seeking, and he applied a different level of the cap to Apple's selling prices. Say that. The second feature of Apple's business is a related point but broader, and it was touched on in our skeleton argument at paragraph 7a. And I mention this for completeness and because from Apple's perspective it's a very important point that they wish this court also to have well in mind. It is the point that Apple is perhaps the most well-known example in the world of a leading-edge technology business that makes multifunction devices. And as I indicated on day, it must have been yesterday, day 3, the Apple devices are the product of many different innovations, and their value has to be recognised and remunerated out of the price of the phone. Within that cellular connectivity, the price for access to the stack is one piece. And the judge referred in his judgment to the expert economic evidence on Apple's side of a Professor Carl Shapiro from Berkeley University. And he set out in his judgment at page 351 a material aspect of the report that he received on that. The relevant paragraph is at the bottom of 351, at paragraph 50. So I'm not going to read that out in extenso, but what he says is that in patent cases there is a tendency to focus with singular attention on the patents in suit and this standard as the whole show, but there are many other things that need to be taken into account, and that a decision maker needs to guard against a result that will mean that there is essentially payment to an owner of part of the cellular stack.
Yeah, well, this is the general point is the danger of anchoring.
Yes,
as we see from the heading at 3, and the examples that are given in 47 and 49 of the professor's report.
That is so.
So you're talking about paragraph 50?
Yes.
Which is cases litigated to trial in the US, which has a jury.
Yeah, well, yes, I'm not referring to that particular part, but to his general qualitative point.
Okay.
That you need to take into account that there are other features of the device which aren't.
But that's not the point he's making. The point he's making is that anchoring is something you need to take into account, something that Mr. Speck urges upon this court.
He does in a different context. So, my lord, on that point, if you look at the way he begins it, he said patent infringement cases focus on the patents in suit, which may cause the patented technologies to be overvalued relevant to other product features, such as other technologies, materials and innovations contributed by the manufacturer. So in this paragraph, I understand your lordship's point, but he is making a point there about how the anchoring can have an effect in that context. And when one puts that to one side and focuses on the value of access to the standard itself, only on that, it's not only right to recognise it forms part of a wider picture, but that also the licensor's patented technology forms only then a fraction to be allocated from that, and perhaps, as in Optis's case, only a tiny fraction. And it was within the context of this evidence that this judge took the view that an aspect of deciding what is reasonable within the meaning of brand, as well as fair between a willing licensor and willing licensee in a more abstract way, can reasonably involve, as he did, first taking a view on what is an implied price for the whole stack from a demand, bearing in mind that the licensee has to incur many other kinds of costs too, for that reason, and then prorating it according to the proportion of the stack accounted for by the licensor before them. And I'm saying this because there is a front and centre attack on the judge's basic chassis, his basic framework of approach. And therefore I'm trying to explain that although this is not, as Mr. Speck rightly said, a conventional comparables approach in the sense in which he rightly explained, bearing in mind this kind of evidence with this kind of case, what the judge did was essentially a reasonable approach. And in this regard,
if you mean the bit where the judge is looking at what the implication, what the implied royalty total stack would be from any given conclusion, I'm with you completely.
Yeah, okay.
That's not new. I mean, you'll tell me I got it wrong because you genuinely do know my judgment in Unwired Planet better than I do.
No,
But I think I did something like that in Unwired Planet. Now the difference is that Unwired Planet was all about percentages.
yes.
And a very important point, which I know is fundamental to your client's case and fundamental to the point you just made,
Yeah.
is that particularly for Apple, a dollar per unit type royalty rather than a percentage is the right approach for all the reasons. I get that completely as far as I can understand it in this case now,
Yes.
although that was a huge issue at first instance, you won and they're not appealing that.
Yes. So, as I understand it, and perhaps I'm to some extent oversimplifying or caricaturing the case against me, but the idea is take a particular comparable, or maybe a small number of comparables chosen by the court as being close in their situation to the licensor's situation. Maybe look at another licensor with a small portfolio as well. Maybe look at another non-practicing entity with a small portfolio or something of that kind, and compare if there are outputs, if there are established rates, those against the one here. Now, and here your Lordship will need to correct me, but I recall in the Unwired Planet case, the cross-check, as it was called, the top-down cross-check, took as its starting point public statements that were made about, because this was the reference I've seen of the way that you described it in the judgment, and those were used as a cross-check in that case to complement the comparables exercise of a more conventional nature. What the judge is doing here is he's taking these license comparables, the Apple licenses in particular, and he's saying, now what do each of those imply for an aggregate stack burden?
I mean, it doesn't matter really, but
No.
I certainly thought, and it doesn't matter, but I certainly thought that somewhere in that judgment there was a calculation, a reverse type calculation of the kind you're talking about. It wasn't just about what people said. You're right. Of course that was there, but I mean, to some extent it's really not that important. But where you take a royalty rate based on somebody's stack and then multiply it backwards to produce what the total stack would be, which is what you're saying should be done. And I don't, as I said, at the level of principle, there are lots of detailed distinctions, but at the level of principle of using as a sense check, well, if so and so is charging this much, what would that mean the total royalty burden would be? If you back calculate it and get it. That's something that's been done well since that case, if not before.
I understand, my lord. On the basis that that's right, and I'm going to take it that that's right, and
It certainly makes sense to me.
No,
Put it that way, Mr. T.
On the basis that's right, in the sense that then supports the submission that I'm seeking to make, which is that what the judge did here is not some freakish departure from what has taken place in the earlier cases.
I think the criticisms, if I may say so, are to do with a more detailed level of generality. The concept isn't a problem to my mind, but the issues are about how you do it, and what conclusions you draw from it.
My lord, we say the same. Mm-hmm. On that basis, because of the way that the grounds of appeal are divided in this case, we say that takes you into the more detailed questions, which are the second group of grounds 5 to 9 in the case, where Mr. Speck has points that he makes, which I've got to then turn to, about whether the judge made mistakes in terms of how he dealt with pass release when he was doing this exercise, what he did with volumes, and so forth. He has a series of 5 points there, and he invites you to consider correcting those, and we agree, and I will need to engage with those in some detail. My point here is that he said it remains his primary case that what the judge did was wrong as a basic approach, in two ways. It was wrong substantively, because it was just, this is absolutely wrong as an approach, and it was wrong procedurally, which I'll turn to, because it was sprung on the parties. And I'm addressing at the moment, and apologies if I've been therefore going through it in too much detail, the point that the basic approach that the judge took was a reasonable approach for a judge in this case on the evidence that he received. That's how I'm addressing it.
Well, I think it's very useful that you've highlighted the issue in that way, and it prompts me to ask this question. Would you accept that there's, first of all, let's start with the basics. There's a big difference between using a top-down approach as a cross-check,
Yes.
and using it as your only methodology.
There is a material difference, I accept. It must depend in the individual case as to the weight that you accord to the cross-check. If it's a secondary method and you're putting them together, or if you're treating it as a light issue that may give you doubt, but would not necessarily cause you to depart from the figure that you had first arrived at, that may be a very different matter. And therefore I accept that if it is merely a cross-check, and certainly if the cross-check is performed on the way that I may have got wrong from Unwired Planet, then that is of less value.
So that leads to the next question, which is, would you accept Mr. Speck's fundamental premise? And if you don't accept it, why not? His fundamental premise is this, that you should only resort to a top-down analysis if it's going to give you a better, in the sense of more accurate result than your comparables analysis.
Answer to that is twofold. The first is that, this is why I say it this way, the first is that as I see what we are calling a top-down approach, in this case, it is a comparables analysis in itself. And that gives the answer to your Lordship's first question, which is that I do not see it as a secondary or fallback point, because the pressing into service by the judge in this case of the real-world comparables in the way that he did is entirely acceptable, and I'm absolutely not saying that it is the way it should be done in every case. It's certainly acceptable in this case as the primary method of analysis of the Frand question. The last point I was going to make on this is that in doing what he did, and again I apologise if I've therefore mistakenly taken this too slowly because I understood the nature of the attack to be more fundamental, the judge endorsed and adopted the core framework of the Apple methodology, which was something ventilated at the trial. And therefore, and this will feed into the point on the procedural complaint, our submission is that he did not do anything strange or novel. And for that, if I can take you to one reference at this point, if you go in the main judgment to page 448, you've got paragraph 405. So here, the relevance of the point, we're on to procedural fairness, I suppose, for this. The Apple framework, halfway down, the basic soundness of approach. Although there were several strands to Apple's contentions, the essence of Apple's case and what served to unite it was a framework. I consider a framework is an inherently attractive way of resolving the Frand question. It's transparent and capable of being consistently applied, obviously. I also consider the essence of the Apple framework, namely the calculation of a stack price, with that price then being prorated according to the proportion of the portfolio under consideration, simply by reference to size, to be, in essence, sound. And our submission, to wrap this up then, in this appeal, is that the judge's basic methodological approach in this regard was not unreasonable. And if Optis is alleging this, as I'd apprehended, it is not a legal error for him to have done it that way. It was reasonable for him to use real-world information as his primary material, working material, to derive an aggregate royalty burden. An aggregate, let me put it slightly differently from top down, an aggregate royalty burden down approach to determining what's a reasonable price for this particular licensor to charge for its portfolio.
Can I stray for a moment into what possibly is your second aspect, the procedural one, but just so I understand?
Yes.
So this was the essence of Apple's approach to things, which the judge thought was sound. It wasn't the approach adopted by Apple's expert.
No, it wasn't.
How far, and this may be the point that the judge is complaining about elsewhere, but how far did the judge have expert evidence as to how things should be approached on this basis, if you were scaling up to get the stack size?
How far was that, you mean, debated at the trial?
It's sort of, I'm moving beyond just debated. I mean, did the experts address how you, I mean, this probably is the judge's complaint earlier. Did he have expert evidence as to how you would scale up and then apportion?
So, my lord, I am going to, again, have to just consider that at least over the short adjournment so I don't misspeak.
Yes.
I do not recall that being a significant feature of the evidence led on either expert side.
No, because neither expert approached it in that way.
No.
So the judge had raw material, but he never had the experts saying, well, if we look at the raw material to get to the stack size, that's how you should approach it.
I'm just checking. Yeah. So, Mr. Sepsio reminds me, you're right, the experts did not approach it in that way. One of them, Miss Guttridge, did have an aspect of her approach, a secondary aspect that was allied to part of the Apple framework that the judge rejected. She called it, for completeness, her economic benefits approach, because she said, well, the pie was not a question of scaling up from any individual license amount, but to look at the price of a basic level handset, look at what amount of profit you get from this.
So
and
this
to
is
look
the profits available approach, which
yes.
we're familiar with from licenses of right.
Yes, yes. And so she looked at a basic level handset, which she said was the right artifact to consider. And in line with Apple's case at the trial, she also looked at the profit on a chipset, which is the part of it that provides the cellular connectivity. And that led her to the figure which, or she worked off the figure that Apple used at that point in its methodology as the amount of the pie to divide, which was $5 or so.
And I can see that's sort of an equivalent, but that's an equivalent that works by looking at DPU or ad valorem rates rather than scaling up and coming down again.
It does. And so I don't say that the experts adopted that. What Mr. Sepsiu reminds me of, and again we'll need to get you there for the references, is that even though the experts didn't approach it in that way, at various points in the submissions we were talking about the aggregate royalty burden, and it was a feature of the case and the submissions presented to the judge.
Yeah.
But we will need to get that to the court as well.
If you're going, I mean, you've made the point that the judge recognised parts of the Apple framework. At the moment, I have to say, I don't have a sense of exactly, to any degree of particularity, what exactly it is you're referring to in the Apple framework, which is what the judge did, beyond the level that we've just been discussing, which is to say, well, if I'm dealing with counterparty A, Apple, I'm negotiating with you, you want X dollars per phone. If I do the math, I can calculate that would imply a total royalty burden on the basis that you have X percent of the standard of this much. That's too much, or it's too little. It's not never going to be too little, is it? It's too much, and that's a negotiation. If that's what you're talking about, then I understand you. If it's something more complicated than that, then I don't understand what you're talking about.
Your Lordship does understand correctly. The parts of the Apple framework that the judge did not accept related principally to what my Lord Justice Arnold has just referred to, which is this available profits basis for deciding what's the total amount of the pie, which then needs to be divided. And what the judge picks up in the paragraph we were just reading, there's one more paragraph I'll show you actually perhaps now, which makes it perfectly clear, is just the general idea that one works out what the overall pie should be, and he didn't do it in therefore the way that the Apple methodology did for that reason, and then finds a share of that to allocate to the licensor in question. The other paragraph I'll show you just to ensure that I've also got this correct is page 466. That paragraph's you see the bottom of the page, 456 and 457. Under the heading methodology, the judge is now laying out what he's done. And he says the best approach, as it seems to me, to resolving this articulation of the Fran question is to seek to price the value of the entire stack to Apple and then apportion the price pro rata among the co-owners of the stack in proportion with their holding as calculated by anography. And he says at the end, I'm pricing the stack and what implementer specifically Apple should pay for it. I'll come back to the question, one of Mr. Speck's attacks is he says that in this case there was a special Apple rate and that was wrong. I'll come back to that. This approach in broad terms follows part of the Apple framework, although I've jettisoned key elements of the framework as unhelpful and wrong. Over the page, the general approach seeking to price the stack is, I would suggest, something of an obvious course, not particularly controversial. It formed a part of Optis's top-down cross-check analysis. Fair point also for this court to bear in mind. And I have no doubt it would have occurred to me in any event.
Just help me there. You showed us yesterday the amended position statement of Optis, in which they had been going to argue for a top-down cross-check analysis, and they deleted most of that.
Yes.
Something was left, was it?
There was. I do distinctly remember that because their same expert, I think he was called Mr. Starzik, said, based on various general sources, said that the total amount that should be payable for this stack was in a range between 8% of the price of the device and 15%, I think, was his range. And having said that, then there was a question, they then said, well, is what we're asking for something that fits within that general approach?
I see, yes.
That's how it went. Now, what's that? I'm reminded by Miss Love that if you go to core volume 3, you can see what was left of the cross-check, so I don't lose it completely while we're on it. Core volume 3, tab 2, pages 36 and 37. Right at the bottom of the page, 46A, this is the part that remains after the crossing out.
Yeah.
Optis also relies on the top-down cross-check methodology to support its case that the Optis rates are FRAND. The top-down cross-check methodology imputes FRAND royalties by multiplying Optis's share based on the PA data, so they approach share in a different way, by a 15% aggregate royalty, which is a reasonable aggregate royalty, their expert said. and then they, in the confidential figures, they work off that in 46B. So that. Oh, I'm sorry. Okay. Sorry. I need to. The point that I'm remind of for complete accuracy is that the 8 to 15% range that I referred to was not just based on public statements. It was based on headline rates that the licensors were seeking. So if Nokia or Ericsson said, this is the headline rate we seek to achieve, then that was taken. And the point made by the judge is that that headline rate doesn't tell me anything about the actual transaction rate, which is negotiated. That was the point. So just to conclude on this, our submission is going to be that in substance, the judge's basic methodological approach, the basic framework that he adopted, it isn't substantively unreasonable. It's not a legal error on that account to have done it the way he did it. And I'll develop a little bit further the point about whether it was procedurally unfair to have approached it in the way that he did, bearing in mind what was ventilated in the trial.
You may not have a view on this, Mr. Turner, but do you say that 10% of a normal phone, normal device, not an Apple, I completely understand why a percentage applied to the Apple product is not the right way to go, I get that.
Yes.
But for a normal type product, 10% doesn't sound crazy as a royalty base, does it?
I'm afraid that I'm not able to assist
Fair
on that,
enough.
my lord.
Thank you.
I would say that you're in a far better position than me.
Well, I don't know
perhaps.
about that either, but all right.
My last point on this, and then move to the next one, is that to underline the point that royalty stacking is an important part of this regime, the ETSI regime, and therefore my Lord Justice Arnold says, well, is it right to take it into account just as a cross-check? And I suppose my answer is there. If it's cross-check light, that may not satisfy the requirements. It is a material consideration that a decision maker should take into account. And the European Commission in particular, when considering the practices of licensing in this field, has repeatedly emphasised that it is a matter that those negotiating, and by inference and extension those deciding where there's a dispute, ought to have in mind. And if I may,
how much credibility does the Commission's view have in circumstances where they propose a regulation to deal with this problem and are then forced to withdraw it, as they did last week?
Well, so my Lord, first I'm going to take you to the existing pronouncement, the 2017. Oh, you're going to know this anyway by heart. But I'm going to take your colleagues.
I can tell you that I'm not going to.
I'm just going to show you part of what has been the approach, and which is crystallised in the 2017 pronouncement. In relation to what my Lord rightly says, we followed that too. That was on the 11th of February. There was a proposal for a set regulation to try to introduce additional clarity in this field, my Lords. And my Lord Justice Arnold's referring to the fact that on the 11th of February, I think it was, the Commission announced that in 6 months' time, it was going to withdraw that regulation because of insufficient support. I don't know if my Lords also picked up that on the 19th of February, quite recently, there's been some pushback from the European Parliament.
Yes, there was a meeting of the Council yesterday and they endorsed it.
I'm not going. Right, well, I'm out.
And if you look at a well-known commentator online, he even tells you the votes, which is supposed, of course, to be confidential, but he tells you the votes and he tells you which way they voted.
Now, in the light of that helpful intervention, I'm not going to be going to the proposal on the set regulation. I'll just show you then, I'll restrict myself to the 2017 one, which therefore remains extant, and which has been a feature of the way that the regulator's been approaching it. That is in supplemental volume 2 at tab 30. So this is November 2017. The EU approach to SEPs, first page, and there's just two very short points on the following page, page 181 of the bundle. Under the heading, 2 at the top, general principles for brand licensing terms for SEPs. Then you have 2.1, halfway down, licensing principles. And you'll see two things. First, in the third paragraph down, reads efficiency considerations, reasonable license fee expectations on both sides, the facilitation of the uptake by implementers to promote wide diffusion of the standard should be taken into account. So this is part of a general policy to ensure that what rates are set don't hinder the development and diffusion of these devices using the technology across the European Union. And on the facing page, if you just look at the third bullet down, finally, to avoid royalty stacking, in defining a FRAND value, an individual SEP cannot be considered in isolation. He said an individual SEP. Parties need to take into account a reasonable aggregate rate for the standard, assessing the overall added value of the technology. And I draw that to your attention without going into a fine analysis of the details of that, but merely to point out that the principle of taking into account the aggregate royalty burden is something that has been a consistent feature. My Lord is absolutely right. I was going to refer to something in this proposal for a regulation. Events have unfolded subject to the one that I was unaware of, exactly as my Lord says. But there was something there too, referring to the same thing. Now, the third point, the last point on Apple's business is something that I've now mentioned numerous times. At the time of the dispute with the licensor flaring up, Apple was licensed to roughly half the stack. You had the 18 relevant license agreements with Apple in evidence as comparables. They extend from a license struck with Huawei, am I allowed to give the dates? Yes. In December 2014, to a license from Panasonic.
Sorry, according to the running transcript, you said 80 relevant license agreements. I assume you meant to say 18.
I meant to say that. That could be a symptom of either the transcribers or my blood sugar beginning to lower at this point in the hearing.
Yes.
They're the ones listed in table 11 of the judgment, which starts at page 482. And you know the list of them. The point is, and I'll try not to labour this too much, the judge heard what was exhaustive cross-examination by counsel about the negotiations, or at least details of pretty well all of them, and he formed a view on the facts that they were the product of not just robust but fair bargaining on both sides, that they were sufficiently reliable for his purpose, and they did not need to be discarded as exhibiting depressed royalty rates. Now, we've discussed the point that in Optis's ground 2 and ground 3, they're attacking the fundamentals of the judge's approach. I've now made quite extensive build-up submissions, and therefore when I address that in a few moments, I can be relatively, I hope, quite brief. But I wish to make one final headline point concerning the non-royalty terms part of this appeal, because that was the matter on which Optis, Mr. Abrahams, closed yesterday. And it's important. It's important to the efficiency of this hearing too. Mr. Abrahams said to you that there are two strands to it. There's the procedural and the substantive. And on the procedural side, which is their ground 13, and I say this for the benefit of the record, and I say this in fairness to the judge, I do need to correct the quite wrong suggestion that you had a judge who would not properly listen to the parties, Optis in particular, concerning the content of the court-determined licence that he had circulated in draft. I'm not going to labour this, but I wish, because I'm not going to be addressing this for reasons I'll come on to in detail. Any fair reading of what happened in my submission shows it was entirely the reverse. The judge circulated, it is true, a draft of his own, having felt that the parties were simply multiplying disputes on a composite draft, and he was explicitly looking to the parties to provide the necessary clarity, and he was open to, and indeed positively invited at every point, submissions, in his words, to improve the drafting of the template license that he presented, improve it. I will therefore not invite you to read now in any detail at all, but if this remains a point in appeal after the hearing, the 5 or so pages of the hearing transcript, which is all there is, which are key, and that is in supplemental volume 1. And I'm going to, perhaps if you open it, I'm going to just take to one bit of it, but the pages are pages 430 to 435 in tab 25. And there is only one extremely short part of it that I'd ask you to turn up now, because we say it encapsulates the essence of it. And I'm not even taking it because it is the most sort of lurid extract in our client's favour. It is representative. And that's on page 435. If you take it from the manuscript, page 93, and just look from line 17. This is the judge in debate with Optis's counsel there. And he says, fair point, Mr. Jamal. It's come through very quickly, but my point's a slightly more nuanced one. That what we get, you see, I find it strange that Optis didn't themselves have any points by which the court-determined licence could be improved. I find that strange because it seems to me that it would be quite surprising if I managed to hit the bullseye in the course of the first draft. What I get from that is that you like the vagueness, and that concerns me, because vagueness is good only so far. I want this to work. Please do not feel that you should not make constructive suggestions to Annex 1, which was the draft, yourselves. You're absolutely right. The intention is to ensure that there is a clear understanding of what it is that I'm directing. The clarity arising of the judgment, but without the opportunistic potentially of making mischief, perhaps in foreign courts, etc. Without opportunistic arguments is something not expressly said in the judgment, therefore it's not covered by the licence. That's the gap I'm worried about. It seems to me that those are the points that need to be dealt with.
And let us hypothesise that Mr. Jamal's response had been, and my impression from what we were told earlier, that she did in fact say this, but never mind whether she did or didn't, let's just assume it. Our position is you should go back to the composite draft, which was largely agreed between the parties, and resolve the differences. Because that was the common position.
Yes. My Lord, I'm coming straight onto that, because we don't want to take up time with a debate in this court over something where we quite see this too, and I'm not going to have a debate about this. For whatever reason, the judge did not receive the input that he wanted on the draft that he circulated. He thought that would be a basis for the parties to collaborate in producing something that would be more workable and certain.
It was a different species of thing, though, really.
It was, well, he saw it as trying to take in plain and simple language the essence of what was being presented to him. Because if you've seen our material, there was complaints, including on Optis' side, that it was becoming, including in relation to some of their own drafting, Baroque and Rococo and so forth. He took a view, which perhaps he shouldn't have done, but he did, that he would suggest plain drafting and then come to court and ask the parties how it could be improved and made certain. Now, for whatever reason, because I agree with my Lord Justice Arnold, it didn't happen. And the document you are faced with is a document which is the product of that not having happened. It's clear. But we are where we are. And it is for that reason that I'm going to try to cut through things on the substantive question, because of course we listened to the exchange between the court and Mr. Abrahams. On our side, we were content with the judge's short form licence. We understand the points that are taken about the judge continuing to think there would need to be an ongoing supervisory role. But we would be perfectly content with the composite draft, subject to settling the terms of the dispute, the non-money, non-royalty terms, in a way that recognises the particular features of this dispute. My Lord Justice Arnold asked before, what's different about this case from other Fran cases? Why did the judge need to go off and do this? On this side of the court, and I can't say how typical this is, but your lordships will have a better understanding of this than me, there was a concern that the party which effectively lost at the trial, which was the SEP owner, appeared to be angling to avoid or scupper a global portfolio licence settled by this court, or at least delay it, and was seeking to focus its energies on the US case about 5 patents to the portfolio. And to some extent, the judge's approach which he took, and all of the provisions that you see about wanting to know what was happening in America and to be able to take steps, was directed to that problem. Now, without going into it, in line with our position, which is that all we want is a workable FRAND licence from the court, and even an interim one, although I confess we have not raised that in terms. In the run-up to this hearing, which the court has not yet seen, before the hearing, we focused very hard on the proposal that was made in Optis's skeleton argument. And may I therefore invite the court just to turn that up. That's their skeleton, page 100 in the core bundle, at paragraph 157. In accordance with what Mr. Abraham said to you, the last part of 157, they were urging that the court can carry out an exercise on the basis of written submissions. You present it with a licence markup to show the remaining areas of dispute. And they're saying there should be a short note from each party to say why its wording should be preferred, and the court would go...
I'm sorry, I must be in the wrong place. Can you give me the page?
Apologies. My mistake. Page 100 of the core bundle 1 in tab 4.
Thank you.
And it's simply the last part of that paragraph where they propose how the court should resolve it. And I say this with some diffidence because we're now obviously at the Court of Appeal level, but that was the proposal which they say should efficiently be adopted. They say at 158 the task could be remitted to be determined, should say in a short first instance hearing, but we would suggest this court does the exercise, and then they outline 4 areas where they say work needs to be done. The first is the way to address the foreign proceedings. Now that is an issue, that is going, unavoidably or insurmountably, that is going to have to be addressed by this court. B, whether the licence should be restricted to the relevant standards. There that means if they're practised in relation to other fields, that they can come back and claim a licence, and that's an issue of dispute. C and D are provisions for breach and termination, which your lordships may have picked up was an issue, because on Apple's side, they said, why are you trying to introduce provisions for significant breach of material obligations and repudiatory breach in the way that you are? Is this because you're looking for a get out or some way of triggering litigation which would then take place in other jurisdictions? And finally, in unspecific terms, specific points of drafting. What we did before the hearing is that we focused on this and we wrote to Optis and we said, look, I mean, we see that there are potential efficiencies, and if you pick up supplementary bundle 5, I don't now have. No, could someone give me a supplementary bundle? One, right. Now I apologise, I now discover my supplementary bundle 5 with the markings is back in chambers. If you go in it, please, to should be pages 136 and 137. I hope your lordships have got this in your copies, otherwise we'll need to hand it up. Do you have page 136,
Yes.
the letter? Good. And so that's a letter. So it was Apple solicitors write on the 17th of February to Optis' solicitors, and they raised the question of the composite document, and they ask whether suggestions, progress can be made. That's at A, and if you look at B over the page, I'm sorry, now this is referring to what was said in the skeleton about the outstanding areas of drafting. That was the question about relevant standards, and we're saying, is that the same argument that had been articulated at an earlier hearing? And we say, can you please explain it? And at letter C, we refer to the further points, C and D. Please explain what your clients consider to be repudiatory and not a material breach, and so forth. And then D, as regards their Roman E, their E, please set out directly the specific points of drafting so we can understand this and take instructions. So there was an attempt to ask them to engage with it. Admittedly, this is 17th of February. Turn over to the next tab, you'll see that they respond. I'm sorry, you need to go to tab 34. Tab 34, you get their response. Third letter on the next day. And we're told essentially that they don't want to get into any of this until this court has dealt with the wider points about the short form licence and whether what the judge did generally, his approach was the wrong approach.
Yeah, well, because if you're maintaining the judge is right on the court to determine short form licence and you prevail on that, none of this arises. Whereas if you concede it, then we can get into the detail.
No, my lord, I do understand that. Just you have the correspondence finishes and then come to exactly what we're proposing, because as I say, the modalities need to be sorted out, but we don't need to take up time arguing about the short form licence in this court.
You're content to go back to a long form licence?
We are, subject to two substantive points, and then we're essentially at the court's mercy on this, because this is the Court of Appeal level, finding the most efficient, practical way of doing it. So at page 141, you have our response on the 19th of February saying, please could we at least leave aside the detailed drafting. We just at least want to understand the arguments that you're making. What's the ambit of it? And we had in mind that it might be something which at least we could explain to the court so that the court had a view on what actually is the scope of what needs to be done. and their response is on page 143, tab 39, and they basically, I mean, things don't go any further. Now, what's happened is that yesterday Mr. Abrahams proposed the parties should provide an updated draft composite license to this court. I didn't understand him to be suggesting that the updated version is going to go back on any of the black text in the latest version the parties had, which was December 2023.
My sense, perhaps optimistically, was that he was implying there might be a bit more black in it.
That's ours as well. That's ours as well. We took from what he said that this updating would really be seeking to agree additional language or propose some competing language to reflect what this court is going to have to decide on the US proceedings side. And subject to Optis confirming that our mutual understanding of that is right, then I am instructed to say we don't resist that. On this side of the courtroom, we do want to get on, and we don't want to obstruct whatever turns out to be the most efficient way of settling these license terms taking place. Now, my Lord Justice Arnold is right in what he said about the response we got at first, because it would be academic if we're pursuing this. We're not pursuing this. We have said what are the things we would like clarified are, at least. We would invite Optis, given that this hearing is continuing at least until Monday, to engage with those questions. So that would ideally need to be over the weekend. If that happens, our understanding is that there will be left only two matters to be addressed by the court on Monday. Those are, there's an issue about what's been called the interest stop date, which will need to be grappled with, because that's worth money, and there is a point of principle there, which I will address. And there is also what is actually quite an interesting question, the question of the basic approach that should be taken by the court to settling the terms, which are not the royalty terms, but the other terms of a FRAND licence in a case of this kind. Because you've heard from Optis, their perspective is, in line with the way that the Court of Appeal in the Unwired Planet case approached things, FRAND is a range. They're entitled to a number at the top of a range. And the question is whether that also applies to all the other provisions of a licence, like repudiatory breach and so forth, or not. And we do have a different perspective on this.
Well, as you say, that's potentially an important issue, but it's one that my immediate reaction is it would be dangerous for this court to try and make a generalised pronouncement on that question without reference to any specifics. Because one conceivable answer, I don't know if it's right or wrong, I'm not suggesting either way, is that you can't generalise. And sometimes that's the right approach and sometimes not the right approach. So without a concrete dispute as a focus for the discussion, I'm a bit wary of going there.
I understand. There are, as we understand it, actually, there are only a small number of provisions that really are things that this court will need to think about, or whichever court considers this question. So one of them is that question of whether the licence should be just restricted to use in relation to the relevant standards. Another one, which is of some concern on this side of the court, is the point I mentioned a few moments ago about Optis's wish to include these additional terms on material breaches and repudiatory breaches and so forth. Our concern is that unless that is properly explained, then there could be a move to create new litigation in the foreign court even before this court, to bring the licence to an end and start over. And in that particular concrete context, the question arises whether, as Optis says, a court in principle should always only insert terms that a hypothetical willing licensor and willing licensee would agree to if they wanted to deal, or whether a court should can take account of the fact that in the case before it, at least one of the parties may be looking for a way to get out of the agreement as soon as it can, in its decision about what it puts in.
Well, that may be a relevant consideration regardless of the wider issue.
I'm sorry, my lord.
That might be a relevant consideration, might well be a relevant consideration regardless of the wider issue. Even if you're looking at just one specific term, it could be argued that it's wholly antithetical to the concept of a willing licensor and a willing licensee, that one of them is looking to get out of the bargain.
My lord, we agree, and that is actually a species of how I sought to express this in the skeleton, which is that in the circumstances, in facts such as these, would a willing licensee, or if it was the other way around, a willing licensor on one side, seeing that they had an unwilling party on the other side, what would they do? So you can treat it in that manner.
Well, no, you've got to be careful, because we're always dealing here with hypothetical willing licensors and willing licensees. It's what the hypothetical parties would do, not what the actual parties are doing.
I agree. The question may be what information the hypothetical willing licensor and willing licensee would have, how much the relevant facts of the case go into the decision that would be made as to the terms that should be settled. But my lord, I say this because we're essentially ventilating the gist of this point. But that point is an issue which we can debate on Monday. And equally, the interest stop point is a debate which we can have on Monday, decide it. For the rest of it, our proposal, in line with the correspondence you've seen and the exchange with the court and so forth, would be that if Optis is willing over the weekend to engage with this, that on Monday there may be crystallised a narrowing of the issues which enables this court to take an efficient decision based on our position that we are not going to fight about the short form licence. That is...
That's helpful, thank you very much.
So, my lord, that concludes my headline points. It does mean that I am going to now go at a more accelerated pace until I run into points where your lordships are particularly vexed. The first part of what I'm about to deal with is grounds 1 to 4. One is the sort of the 5 general principles of Frand that the judge completely misunderstood. 2 to 4 are the group of grounds saying that his entire methodology should be put to one side. A lot of, therefore, what I'm going to say I can take much more quickly now because we've covered a lot of it. Then when I get on to the more detailed grounds that Mr. Speck covered, grounds 5, 6, 7, 8 and 9, I apprehend that the court will have more questions for me. That's not to say you won't on this first lot either, but so that we can pace this by reference to how much of the hearing there is. And Mr. Mercer reminds me, because he's dealing with America, that I mustn't.
He needs some time
He needs time. I'm going to work on that basis. So I begin with grounds 1A and 1B of the appeal. For ground 1, if you would please open the core bundle to look at the grounds themselves in tab 2 on page 14. You have set out here the 5 principles in letters A to E. And the first principle that Optis says the judge misunderstood or misapplied is that for and, the question must be answered by considering what a willing licensor and willing licensee would agree, absent, hold up and hold out. And the second principle is that hold out of any kind, underlined, is inconsistent with the ETSI framework, and then underline this word please, therefore will have a depressive effect on the resulting royalty. And I'll be coming back to the use of the causal framing of this, therefore. The statement in ground 1A is materially identical to the way that this court has crystallised the basic principle in its recent case law, as this court well knows. But the use, we say, of the term of art hold out in B and in A is not. And it's convenient, if I may, to go to the interdigital case at paragraph 40. It's the second authorities bundle, tab 4. Page 292. These are very succinct and, if I may say so, very clear statements of the law. And you'll see in paragraph 40, first few lines, the statement of the principle, willing licensor and willing licensee. The 5 lines down, in the present context, for the reasons given above, a willing licensor is one not intent on hold up, a willing licensee is one not intent on hold out. And a little earlier in this judgment, the court has set out the Supreme Court's discussion from Unwired Planet of the ETSI IPR policy, in the course of which it identified what constitutes the mischief of holding out. So you go back in the same judgment to page 205, and that sets out paragraph 10 of the Supreme Court. And again, I apprehend at least two of your lordships will know this by heart, but about halfway down the big paragraph in the middle, you have the discussion of hold out and what essential mischief is. This objective seeks to address the mischief of holding out, by which implementers in the period during which the IPR policy requires SEP owners not to enforce their patent rights and so forth, might knowingly infringe by using the invention in products which meet the standard while failing to agree a license on FRAND terms, in circumstances where it may well be difficult for the SEP owner to enforce the rights after the event. Implementers might use their economic strength to avoid paying anything to the owner. They may unduly drag out the process of license negotiation and thereby put the owner to additional cost and effectively force the owner to accept a lower royalty rate than is fair. Now, there are 2 points to make about Optis' submissions to this court in the present case in the light of this. The first is that the judge in this case was fully aware of the meaning of holdout, essentially here, used as a term of art, and he was aware of the mischief from holdout that needs to be guarded against. And if you put this away and go back to the judgment, he demonstrates it really at the very start. I'll give you this. When he's introducing the concepts of hold up and hold out. In the judgment itself, if you go to page 240 of the bundle, you need to pick it up at paragraph 9. And you see in 9 Roman 1, near the foot of the page, first you've got the discussion of hold up and what it is, giving the owners of patents excessive power to disrupt an otherwise global market to the prejudice of manufacturers and developers using the standard, implementers, by exacting excessive royalties for the use of their inventions, by threatening and even obtaining injunctions against the use of the technology in one or more jurisdictions. So coming back to a point that we debated yesterday, he is using hold up in that more narrow sense of the use of injunctions. In the footnotes, it's footnote, fourth one down, he stresses he's using the phrase hold up as a term of art. And if you go over the page to the top of 241, he is also now dealing with hold out, and he refers to that as a term of art. And he describes the mischief from hold out in the last 4 lines. It's undesirable. It may enable implementers to avoid paying an inventor a proper price for the use of its invention internationally, or at least delay the point in time that the license to the patent, together with the inevitable obligation to pay, comes into play.
Yeah, well, that's fine. The problem is the footnotes. So we have footnote 8 and footnote 11,
Yes.
which tell us that there is something called legitimate hold-up and illegitimate hold-up, and legitimate and illegitimate hold-out. Why so?
And that is because, my lord, he is distinguishing the conduct that he has just referred to, which falls into the category of the illegitimate on both sides, from what he then goes on, I'll now give you the references, to refer to in a looser sense.
Yeah, but the fundamental proposition is that you can have legitimate hold-up and you can have legitimate hold-out. And that is the proposition that I'm questioning. Do you seek to defend that proposition, and if so, how?
I do not seek to defend that proposition, provided the term hold out and hold up are interpreted in the way that the judge is identifying here as giving rise to mischief. I do not wish to get caught on a semantic gorse bush, because if, as I will show you, he is using the terms in a wider sense to mean behaviour that can take place in negotiations, which is the normal cut and thrust of parties dealing with each other, which doesn't entail these mischiefs, and he does use the term, and I understand it's dissonant
You're
and
right.
wrong.
You're right to try and avoid being caught on the semantic gorse bush, but the argument against you is that that's precisely the trap the judge fell into.
And my response to that will be that the judge does use the term hold up and hold out in the way that my friend now deploys in this appeal, but where he refers to it in legitimate terms, he's there not talking about the kind of behaviour that this court rightly castigates as being hold up and hold out without applying the adjective. My submission is that the judge, in referring to legitimate holdout, and I'm not wincing as much as the members of the court, perhaps because I've had less exposure to this field, it was a way of responding to how Optis itself was liberally using the term holdout throughout the trial to signify any kind of resistance by any licensee to demands made by a set licensor, at least where they were supported by some form of explanation, possibly accompanied by a template document saying approved by Mr. Justice Birss. Now, we've given examples in our skeleton argument, which was page 156 of the bundle at paragraph 39, of the sort of behaviour that at the trial was referred to as hold out, the term being used by Optis, by its representatives, by its witnesses at the trial. If you look at paragraph 39C on that page, 156, of our skeleton, call 5, Optis seriously put forward the fact that it took several attempts to contact a very small company, one of its comparables called Blue, as an example of what it called significant and material holdout behaviour. And it asserted that almost any questioning by Apple of the strength of the portfolio being asserted
Sorry,
against...
what's wrong with that? Why is not a deliberate failure by an implementer to respond to requests for licensing negotiations evidence of holdout? Why is that in any way wrong?
Now, my lord, if what is going on is some deliberate failure to respond, I understand that.
But that's the allegation being advanced.
Well, as we understood it, and this was also a matter that was addressed to some extent in cross-examination, this was a small company that wasn't responding to certain approaches, but whether that was as a result of some deliberate conduct to try...
That's the question of whether the allegation is substantiated. But the allegation is one that is perfectly consistent with a proper understanding of holdout.
I'm with your lordship insofar as the behaviour that we're seeing was essentially a deliberate refusal to engage with a licensor in a reasonable time frame. If, however, taking into account the imperfections of the way people essentially deal with each other, and even companies deal with their suppliers, there is an overlooking of correspondence, matters of that kind, and therefore a failure to engage with a request, that we would not say is holdout, it's just something being interpreted in that way by one party. Another point, and I'd need to find you the reference for this as well, but it's referred to somewhere in the judgment, it's a slightly different point, is that in a lot of the negotiating documents, the judge makes a specific finding about this, and I'll get this drawn to my attention to find out where it is. In a lot of the negotiating documents between Apple on the one side and the big licensors on the other, there was very often, on both sides, accusations of hold up and hold out. So very often you find you're now not behaving as a willing licensee, you've lost your protection, I'm going for an injunction, and so forth. This was such a consistent feature of the behaviour, the judge does refer to it, and he takes into account, if you're looking at it commercially, that these negotiators know what they're doing, and this is to a large extent positional as well. And so merely because parties refer to these sorts of things and make these allegations is not the end of the story. The judge's perspective is that you have to cut through that and try to get a deeper understanding of the commercial dynamic. Because the judgments of the courts, the approaches to how FRAND is dealt with, they are then picked up by these big industry parties and the way they relate with each other. And all this is to say that the references at the trial to holdout behaviour in various ways were rather overdone, as we'll see in a moment the judge himself finds. And perhaps ill-advisedly, he does draw this distinction between what he calls legitimate and illegitimate hold-up behaviour, which has now become a feature of this appeal. May I say, though, before just leaving this question, it is instructive to see how at least one other patent court judge who's dealt with these cases referred to the substance of the point, and that was Mr. Justice Mellor in the interdigital case. If you pick up his judgment, that's in Authorities Bundle 2, tab 3, he said something about it on page 160. And I accept immediately, look at the sideline paragraph 278.
Sorry, which...
This is Authorities 2...
Yep.
tab 3,
Yep.
Mr. Justice Mellor's judgment, page 160, and on that, near the bottom, second hole punch, paragraph 278, he's talking about the terms, and he says in the previous paragraph, I adopt the same definitions as Mr. Justice Birss in Unwild Planet, which I believe to be the standard meanings of each term. He knows what he's talking about. He says there's one general observation to be made about these terms. Every SEP licensing negotiation involves some degree of hold up or hold out, and probably both, for as long as the two sides fail to reach agreement. Depends on the eye of the beholder as to which is occurring. However, the mere failure to reach agreement doesn't necessarily mean that one side or the other is to blame. There might be genuine disagreement and so forth. So what he is saying here, at the very least, is that in any negotiation, I mean, even taking the narrower meaning of this term, you're going to find some elements of this behaviour. And he's saying that before one essentially cries foul and says this is hold up or hold out, that in some way invalidates or disqualifies a comparable from usefulness, take into account that in commercial negotiations, this sort of
I
conduct...
understand the point Mr. Justice Mellor's been making to be the exact reverse, namely that what you actually find in reality is that both sides are guilty, on the one hand of hold up and on the other hand of hold out, because the court will arrive at a frown rate which is in the middle.
Well, no, my lord, I see that he is using hold out and hold out in that way. My point here is the slightly different one, that he doesn't, it may be that that's the implication of where it goes. I was interpreting that as meaning that in any commercial negotiation, I mean, he says one sees elements of this sort of behaviour. Whether that means that one needs to adjust in relation to every comparable to try to take account of that and calibrate it in a more precise basis, I would doubt.
Because, I mean, that must be the core question. When you look at a comparable, has there been behaviour such that it was or was potentially distortive so that you shouldn't regard it as a comparable for what on the face of it shows?
Yes, that is the essence of our submission on this point, and why I was drawing attention in referring to the grounds to the use of the word by my friends, therefore, in principle B, 2B. Because you see now from after this debate, the way they put it in 2B is hold out of underlined any kind is inconsistent with ETSI. And then you get the word therefore, any form of holdout is inherently illegitimate. And then you get this, and will have a depressive effect on the resulting royalty. So the proposition in the case against me is that that is the causal chain. And you've heard from Mr. Speck, the way that it's presented to this court is that because of that, these comparables...
But would you go any further than saying that the word will should be replaced by the word may?
I entirely take that point, but I say it's not simply, that's a big point. Because my point is that therefore...
Well, I want to be clear. You're saying that this principle is wrong, and I want to know how far you say it's wrong. And I think you were close to accepting that if we substitute the word may for will, it's correct.
I'm not contesting that, my lord. No.
Thank you.
I fully accept that. What I mean is that because it is may, the question for this court or a Fran's court looking at comparables is whether that may has crystallised into something that it believes has happened. Now, the judge's conclusion on all of this, if you go in the judgment to page 480, in paragraph 4812 really shows the point that I'm trying to make about how this judge was using these terms of art, and he should not perhaps have expressed himself in the way that he did, but what he thinks. He says, Optis devoted substantial amounts of time cross-examining Apple's witnesses about holdout, and the substance of the case is that comparables can be relied on because the rates were unduly low. So, see his phrase, unduly low, come back to that, because of Apple's holdout. I have not accepted this contention for a number of reasons. In the first place, I don't consider that Optis came close to differentiating between legitimate bargaining and illegitimate bargaining. Every effort by Apple to fight its own corner, essential part of any market economy, was labelled holdout. I don't consider that to be a sound approach. Very early in this judgment, and that was the bit we looked at, I expressed the view it would be necessary to consider the difference between legitimate and illegitimate holdout. Seems to me that only the latter, and then there's this, here's where the may comes in, to the extent it actually depresses rates can be considered. And you get the conclusion at the end of that paragraph. My conclusion is that Apple negotiated properly. And my point is this, I'll return to it under ground 3, but the judge's conclusion there at the end that Apple negotiated properly was looking at the company's behaviour in the round, having heard, as he says, a huge amount of cross-examination. What he did not do was pick out an element of the negotiating conduct in isolation, and Mr. Speck has developed that before this court as to the essence of what he says this court must be impressed by. The main feature being Apple's position, which you saw stated, that it was ultimately reserving the right to test the merits of individual patents asserted against it in negotiations with licensors, and then claiming that this upended completely the fairness of the whole negotiation. The judge saw, and you see it from the part I've just read out, in line with what my Lord Justice Newey says, that the acid test, if you're assessing comparables from this vantage point, is whether in the commercial context, the behaviour in question has actually produced the effect of depressing the rates to sub-Fran levels. At numerous points in this judgment, what the judge does, and again, it's not a linear judgment, he shows he is on guard as to this. So if you go to page, on the same page, if you go to page, same page, 4814 at the foot of the page, this is not a separate consideration. He's referring to the bargaining power. And he says when you're considering comparables, the relative bargaining position of the parties are critical. And on the whole, he considers that Apple's counterparties are big beasts in the world of cellular connectivity and generally, and well able to look after themselves. Then he adds, where I've got doubts, and consider Apple may have been able to deploy to adverse effect its undoubted commercial clout and market power, I will try to factor this into the assessment. That then takes us to what we debated at the beginning of my address, into how he dealt with that in the Qualcomm adjustment.
Can I just pick up that discussion in a way? In that section where you get paragraph 371, the judge then goes on to address the competition law question of abuse of dominant position and so on.
Yes.
That was something that was argued, was it? Abuse of dominant position.
Yes, it was argued. That was not out of the blue. The way it came into the trial was that Apple ran a case which did not succeed, that the behaviour of Optis which was a monopoly owner of its set portfolio, was contrary to the European competition rules because of the things that the judge ultimately found as facts, that they negotiated in an entirely erratic fashion,
Yes,
and so forth. And the judge, there are different parts of his judgment dealing with abuse of dominance, but the judge said, I'm not having any of that.
yes, that's right.
What's that? Oh, is it? Oh, I'm sorry, yes. And then Miss Love just reminds me, so I don't need to refer to it later, on the point I made earlier about the way in which, in the trial before him, this use of the word holdout was used, not just by Optis, but he saw from all the ways in which, in industry negotiations, people use the term, is dealt with on page 374 at Roman 4. The judge says, in the correspondence between Ericsson and Apple, to which I was taking in the cross-examination, there are many references to Ericsson's upsetness and their disappointment with Apple, given Apple's stance at various points in time. Such language featured in other negotiations too. At times, suggestions of bad faith or absence of bad faith are made in by the negotiants. I can't regard such assertions taken out of their context as probative of anything. These were hard-fought negotiations between opposed parties, culminating in the case of the comparables in an agreement. The reason why it was relevant below was because the cross-examination was being relied on, these documents were being relied on, put to the witnesses, look, this party is upset, this party accuses you of bad faith, so forth. The reason why it's relevant on this appeal is because Mr. Speck redeploys it for his same closing submission, setting out the same extracts of documents, and that's his case. So that is all I want to say about the first two principles. As I say...
so can I just put one thing briefly to you? I'm sorry to take you back to page 480. You were making submissions on page 480, I think it was certainly little 2 is the bit I was looking at. Have you got that?
Yes, I have it.
A bit of this that slightly puzzles me is one way of reading the paragraph there, this is the one that ends negotiate properly, is that the way to identify illegitimate holdout is to work out whether it actually depresses rates. But the problem is that this exercise is the other way round. You don't know what the rates are, what the correct rate is. You can only do that if you've already decided what you think the right rate is. And I'm just concerned that is that a fair reading of what's on the page?
So I would say no, that's not the correct reading, because the correct but I would like to make a point against myself in a moment. But I'd say it's not the correct reading, because if you look in 4812 and we go back to that sentence, it seems to me that only the latter, which is the illegitimate sort, to the extent it actually depresses rates, can be considered. The process he seems to be following is first decide if it's illegitimate or legitimate, then, following my Lord Justice Arnold's approach, ask yourself, what is the acid test? Does it, in the commercial context, actually depress the rates? The point against myself is that, well, I say against myself, essentially it's a criticism, partly accepting what Mr. Speck says about this, is that he does go on in the next subparagraph to look at these various behaviours he talks about, and as Mr. Speck says, he says, I do not consider them, at least at the time they were made, to be badges of illegitimate holdout. I consider Apple was perfectly entitled to advance all these points at the time. Two things about that. I mean, he was right in terms of the view of the law. This is before Unwired Planet, and quite an important change in approach. So he's absolutely right in what he says. But
it's irrelevant.
But in terms of what Mr. Speck says, I'm not going to contest that if that was a bad thing at the time, it was a bad thing at the time. The time frame shouldn't matter.
And why does the decision of the Supreme Court make any difference? We operate on the declaratory theory of law, so that was always the law.
There is that, and I understand that analysis, my lord. The key
Are you
point...
saying there's anything wrong with it?
The Supreme Court's entirely wrong. No,
No, that's not the point. No, seriously. The serious
I-
point is,
yes.
are you contesting that the Supreme Court's decision was declaring the law and therefore that was always the law?
My lord, I'm not. What I would say in response is two things. The first is that the Supreme Court, when it declared the law, which was always the law, was nonetheless not reflecting what in the industry had been understood to be the law, even in this jurisdiction, before that point. Second point is the one that I was going to go on to make, which is that the acid test remains what the judge does correctly appreciate here, which is I've got to ask myself when looking at these comparables, if they're reliable, by saying, well, look, was there actually an effect on rates?
And when you say, was there actually, you run into my lord's problem. I suppose the core question is it behaviour such that it can be expected to have had an effect on rates?
I accept that. In a sense, it can be expected. One can presume, yes. As opposed to there being, because it would obviously also be sufficient and better if there was actual evidence of some nature.
But then if you had that, you wouldn't particularly need to worry about whatever you call it.
No, you quite. However, the question whether one can expect it or presume it requires a sophisticated understanding of commercial dealings and how industry negotiations work, on which subject matter this judge saw days of cross-examination and reviewed reams of documents and was in a good position to make that judgment. So we will come back to what we say is the essential question, whether a reasonable judge, it is being said, could have reached the decision he did, not unduly low rates in the way referred to in the first subparagraph of 481, or not. And our case is that it's not merely relying on the fact it being a high bar, although it is a high bar. There was ample material for the judge to have concluded this in the way that he did. So, and now, in fact, with an eye on the clock, I'm going to see if I can at least reach the end of ground one before the short adjournment. We turn up Optis's ground 1C, that principle, at core 1, tab 2, page 14. The next thing the judge is said to have got wrong is the proposition that a lump sum consideration in an existing or putative license is a liquidated sum of money underpinned by the application of a running royalty rate applied to an estimated sales volume over the relevant term, and or a lump sum consideration necessarily implies a running royalty rate, even if not negotiated on that basis as a matter of fact.
Again, do you take issue with that principle? Whether the judge got it wrong is another different matter, but do you take issue with the principle?
We do not take issue with the principle that there is a relationship which exists between these various factors, leading, if you're looking forwards from what is negotiated to the production of the lump sum. Interpreting the last two lines in subparagraph C and or a lump sum consideration necessarily implies a running royalty rate, even if not negotiated on that basis as a matter of fact. With that qualification, it is backward looking, so that if it's not been negotiated on that basis as a matter of fact, the phrase necessarily implies must be looking at the vantage point of a decision maker retrospectively.
Yes, to be sure.
Yes.
This is what unpacking is all about.
Yes. And I am not disputing the sense of unpacking. The only qualification that I will enter in line with what I've already said is that in doing that sort of unpacking, we might be returning to this, the considerations, let's say the ones that we have in this case, were lump sums given in return not merely for SEPs, but in many of these cases for a range of other valuable matters. And that means that if one is merely doing a division after the fact, there is a logical flaw if one is implying that it all in fact relates to the SEPs. There may be a need directionally to take account of the fact that some of that consideration is attributable in reality to other matters. The point taken against me and in opposition to the judge's decision is that he is said to have regarded lump sums, I'll return to the point I made yesterday, as their words from the skeleton, paragraphs 78 to 80 and so forth, strictly distinct from per unit royalty structures, and that the judge believed it was, in his words, impermissible to unpack. In other words, there isn't a relationship, it is impermissible, and these are logically separate categories. That would be, we agree, an error, were the judge to have proceeded in that manner. As my Lord Justice Arnold said on Tuesday, and we entirely accept, lump sums in the abstract are meaningless. However, ground 1C is a significant example of a misstatement of the judge's approach and his reasoning, because we say it is plain from the judgment that the judge's view, having heard and read the evidence on commercial license negotiations, was that the agreed lump sums do naturally bear a relationship to selling prices and to estimated sales volumes by the licensee. He did not regard the per unit approach as something strictly distinct or independent, and on the contrary, he explicitly says that selling prices and estimated sales volumes are key inputs for the arrival at a lump sum. The judge's point was that the final agreed amounts in lump sum licenses are typically, on the material he saw, the product of a wider negotiation where other factors can also come into play. And although some of it is buried, unfortunately, in footnotes, the judge does make this clear repeatedly in the judgment. So if you look, for example, in the judgment at footnote 300 on page 346, the judge says, "I'm not, of course, saying that ASP and volumes of sales would be irrelevant in negotiating a lump sum rate. That would be to disregard two key factors. But I'm also not saying that a lump sum would be merely the conversion of estimates of volumes sold and ASPs into a present value. What I am saying is that a lump sum would be a negotiated rate taking account of volumes sold and ASPs as well as other factors." Now, in short, if you now go forward to page 390, just give you a couple of references on this. The judge, he's not in any doubt that it is perfectly possible to convert or unpack a lump sum Apple license into either ad valorem or per unit rates. The royalty structures, as he calls them, are not treated as strictly distinct categories. And on that page, you see him discussing lump sum licenses in paragraph 303, Roman 1. If you read from the second sentence, you see, of the third line, of course, the parties will doubtless have well in mind the volumes likely to be sold and the prices at which they will be sold, but this data will not be available from the face of the licenses. Converting or unpacking a lump sum license into either ad valorem or per unit thus will typically involve making assumptions about volumes sold or ASP. This data will not always be readily to hand, and it's quite possible that the parties are very much not in agreement as to how it is calculated.
What's the relevance of that? Why is it relevant that they had different views as to sales volumes? Because once you've closed on the price, you can work out what's being assumed, and it may be somewhere between the parties' positions.
You will, yes, you will take a figure, but I mean, if take for example the difference between past and future, you can't.
The judge
you can't.
The judge seems to think there's a problem with the fact that parties may not be in agreement
Yes.
as to how the lump sum is to be calculated. But I'm saying, why is that a problem?
Because you then have to, if you're going, well, take the point I was just about to make. If the court is faced, if you've got a general release and a future term of 5 years, and the court has to make a decision, this is the point that emerged from the Ericsson negotiation, about what the rate should be, you've got the question of spreading the consideration over a number of years, which includes the unknown question of the past, and the rate that should be attributed to the past as opposed to the future, and matters of that kind. What the parties in question will have arrived at is a lump sum that they're both happy with, and the negotiators take back to their principals and say, we've got a good deal. But those sorts of considerations, which are going to be relevant to an unpacking of the licenses.
Yeah, but frequently you've got no idea. You know, the frequent problem with these scenarios is you don't actually know what the negotiators took into account.
Yeah.
And therefore, when you unpack, you have to make assumptions which are objectively defensible assumptions. But that's what's the problem with making assumptions to unpack on what you think is a reasonable basis?
My lord, there is none. I do not interpret the judge as saying, this is the insurmountable, unavoidable point again, that to do that is objectionable in itself. What I do see him as saying here, and he says it elsewhere, is merely surfacing the point that to do this involves making assumptions, as your lordship says. That is the gist of what he's pointing out. And the essential, my starting point, to come back to it in response to the point made against me, therefore, is that he is not treating these as separate categories which can't be translated into each other. He is merely pointing out that once you start the unpacking exercise, and I agree with my friend, by the way, that in some respects some of this is going to be unavoidable, however you slice it, you are going to be making assumptions. What I'm going to show you is that the judge is, it could be more perfectly expressed, but he's aware of this, and that his approach is essentially, in one sense, trying to minimise these difficulties. And if I can cut to the chase on that in the interests of efficiency, when he's dealing with the Apple licenses, he does make, and he says it certainly at a couple of points, he's making an assumption that these Apple licenses all involve selling by Apple of these devices within this particular time frame, and he's assuming, because it's implicit, that it's at roughly the same sales volumes, and that when he observes these lump sums, he doesn't therefore have to unpack down to a particular rate and then repack back up to lump sums, making assumptions. Now, the question for the court, the strong question that is facing you, is whether that simplifying assumption, which he undoubtedly makes, is a reasonable one or not. And I will come on to that, because that's one of their distinct grounds of appeal. But that is what he's doing. And therefore, when he is approaching the question of comparing these licenses and so forth, he's not saying that unpacking is something impermissible and foreign to his exercise. He's seeking to simplify and to avoid one element of complexity which would otherwise arise. Now, what the judge was vexed by in this case, therefore, is not the belief that lump sum licenses, by their nature, it's objectionable to convert them. We come back to the first point, which I'm not going to go back into in detail, that he felt that he wasn't able to rely on the work that had been done by the parties' two experts in their different ways in unpacking in this case, and on the assumptions that they had made, because for the reasons that he'd explained. And finally, because Mr. Speck understandably referred to it, I would refer to the criticism, one criticism of Apple that was made by the judge in the consequentials judgment. That was in, that's called volume 2, tab 1, page 8. There's a footnote which my friend took you to about what Apple was saying at trial about the lump sums and the relation to the unpacked, to these elements, volume and sales. But before you look at the footnote, you need to start on the previous page at 8 with what the judge is saying, to which the footnote is appended, and that's in Roman 2 on paragraph 11, page 8, about 5 lines up from the bottom, by the hole punch. It says, the judgment doesn't accept that lump sum rates are simply the mechanical product or outcome of volume sold or anticipated to be sold and the ASP. In short, lump sum rates are not the arithmetical outcome of an ad valorem or per unit rate multiplied by volume. While ASP and volumes are unquestionably relevant and important factors going to the negotiation of lump sums, other factors, and those are likely to be different according to the party, will play a material role. So he's repeating the point that we've now seen adumbrated in the main judgment, and we agree with that. The point that was made by Mr. Speck was about the footnote 19 that you see, second one down. It was for this reason that I rejected, in trenchant terms, a suggestion made by Apple, and ostensibly not contradicted by Optis, that lump sum rates were simply a mathematical product or definable, of definable identifiable factors. That's emphatically not the case. The factors going to the negotiation of a lump sum will be multifarious and subjective. Mr. Speck...
And that's counsel of despair, isn't it? Because if you really think that, you could never rely upon lump sums at all.
Yes. No, absolutely right. All I wish to do here is to clarify that this was a case of crossed wires, which we regret. As we've indicated in our skeleton, essentially, you've got two separate things. You've got the approach that's taken to calculating a lump sum that comprises a starting point for negotiations. And as my Lord Justice Arnold rightly points out, you've got the retrospective position of a decision maker, a court, now faced with an exercise in working out a Fran value. But you also have the question that the judge is here referring to, which is the actual commercial situation of what goes into influencing a final lump sum amount which is agreed as the result of the negotiation. And we were not saying, or we did not mean to say, and this will be therefore, I will accept, our fault, that these licenses, the lump sums you see, are the product of a simple calculation of that kind. Indeed, it would have been inconsistent with the Apple framework, where we talk about taking into account other factors, as it was the fourth part of the framework, for me to have said that, or for us to have said that in our written submissions, and we did not mean to do so. So with that qualification, that is all that I wish to say about ground 1C. If I can, I'm going to try to finish at least ground 1 before the short adjournment on day 2 of my submissions.
Okay. Again, principle D, is it wrong?
Principle D, just pick it up. No, but what we do say is that what is sought to be derived from it is a straight misreading of what the judge did, the way the use is subsequently sought to be made of it. So, to pick up your lordship's point, that ground is the proposition that the judge misunderstood that FRAN terms should reflect the true value of the SEPs to which the licence relates, without there being any adjustment depending on the individual characteristics of a particular market participant. And you've heard the case presented in court by Mr. Speck that what the judge did was lose sight of that and look to award a special rate for Apple. Now, it's not entirely clear if you go into the main judgment, go to paragraph 84 in the main judgment. So I'm just going to have to get my something correct in my note. Let me put that to one side. We're saying that the complaint essentially that there's an error in what the judge said. There's a cited paragraph of his judgment, if you go in a skeleton to how they deal with this at ground 1D. There we are, paragraph 83 on page 74. You look in their skeleton at paragraph 83. You'll say that the judge, at a particular point, and they quote the paragraph, is committing an error there. So that's the way that they are putting the point to support the case that the judge got this wrong, because he was looking at the individual characteristics of Apple. And if you cast your eye down that paragraph, we say it's not entirely clear how this extract from his reasoning bears on the proposition in ground D, which is the thing that he's meant to have mistaken. But then if you go to paragraph 84, that's on the top of the following page of their skeleton, the gist of what they're saying there seems to be that the judge didn't start out by calculating a per unit royalty for Optis' portfolio, which would be applicable to any licensee, and then getting to lump sum payment due to Optis from that. It's the point that his unit of currency that he worked in was the lump sum payments which Apple had made under different licenses to Apple specifically from which he derives the aggregate royalty burden for the stack. So if I may then focus on the paragraph in the judgment that they say is the problem, you find that, I apologise for the error before, page 457. And you see it at paragraph 433 Roman 3. You start at, read that one first, it's Roman 4. If you read Roman 3, he's making the point that the key differentiator between the licensors, based on the analytical framework he's adopted, is the different proportions of the stack that they have. This, of course, is the essence of the Apple framework, and it seems self-evident. He explains it in self-evident terms. Then in the paragraph subject to scrutiny below, all he goes on to say is that if an implementer pays different SEP owners on different bases, you could run into a practical issue about ensuring that that principle of proportionality is kept to. And our response is that this is not an issue of principle, and that is why in the last 2 lines of the paragraph, subparagraph, the judge emphasises he is certainly not going to so far as to say that such issues cannot be resolved. In other words, he's not saying he should determine a special rate to Apple as opposed to other market participants. The reason why the judge, in our case, focuses on the 1.8, not 8.0 licenses to Apple, is made clear by him in the judgment. And it's the point I've now already flagged, which is the assumption that Apple is broadly anticipated to sell roughly the same volume of device sales in each case, and it's similar types of devices, and that enables the judge to treat the lump sums in each of them on an annual basis as sufficiently comparable. And on that, if you go to page 470, I will go to 2 references that Mr. Speck took you to, again in footnotes. Page 470. At the top of the page is paragraph 464, and this perhaps gives the best prospect for my friend of saying, well, he's looking only at a special Apple rate which wouldn't be applicable to other people. And he says, assessing the lump sum price for the stack, total price, for use of the cellular standard, irrespective of ASP and volumes sold by Apple, underlined, is mainly achieved through the use of the Apple comparables. The Optis ones can't be used because of too many subjectivity, and in any event, for the reasons given, a lump sum must be calculated by reference to the implementer seeking to license the portfolio in question, which the Optis comparables do not. And then you need to go to...
By definition, I mean, I'm still struggling to understand what on earth he can mean by that. Because at the moment, it seems to me the very opposite is true.
Well, my lord, I would agree that that is not expressed well. I think that the footnotes have to be read, and I'll have a different take on them from my friend to help illuminate what was meant. So at 598, he says, although the ad valorem price can plausibly be charged unchanged to all implementers, a lump sum must obviously vary according to implementer. Although the lump sum may not explicitly be calculated by reference to ASP volume sold, those factors will obviously have a bearing on the value of the license to the implementer. Calculation of the lump sum price must therefore be specific to Apple, and the Apple comparables are therefore of the most significance to this part of the exercise. So what he's saying is, and he makes it clear in other places, is if I was to look at a lump sum price in some totally different case to a smaller counterparty entirely, take some of the Optis licensees, of course that wouldn't be in any way useful to a comparison such as I'm trying to address. His assumption here, and it is not perfectly expressed, is that he can do it with Apple because the volumes and the ASPs are pretty well constant between these different lump sum agreements. And he says in the next footnote, to back that up, something which is almost in line with this. The Optis comparables, even if unpacked, would represent the lump sum price paid by Optis's counterparties, who are all, with the exception of Google, far smaller than Apple, and so would pay a lower lump sum in any rational market. We agree, but there is a mistake from our side, unfortunately, because he should not have singled out Google either. Google is a large and powerful company, but when you appreciate that the volumes in contention for Google were a tiny fraction of those for Apple, the same point applies. And that then forms the basis of my friend's complaint as the mainstay of their ground 8 of the appeal, that when the judge is analysing all of these licenses to get an implied total aggregate royalty per year from them, he takes the 18 Apple licenses, he makes that simplifying assumption, but then he throws in Google too, and my friend says, well, this is a mistake, and he's right. We're not contesting that, because he doesn't adjust it, realising that Google's sales volumes are much lower, and that there should be a far higher figure included if you're putting Google into your analysis. And so when you look at this footnote 599, that reference to with the exception of Google is something that we say there that the judge did get wrong. So I hope, my lords, that sufficiently explains my case. I'm conscious of the 45,
Yes.
maybe less than that, because you've got to rise at 3 o'clock.
You certainly have to rise at 3 o'clock. If you wanted to complete your ground 1 and could do that in the next few minutes, we could take 45 minutes from that point.
I've got almost nothing to say about ground E. If you just look at it, so I can deal with that in a couple of minutes. Ground E, saying that you've got to disentangle, as Mr. Speck rightly said, working out what's a comparable and then unpacking it. That is uncontentious, but we say it doesn't go anywhere. We've explained in our skeleton argument that the judge was quite plainly under no illusions about those things being different. In view of their skeleton, it's paragraph 85, they do appear to be taking a semantic point, because what they do is criticise the judge for having said at one point in his judgment that unpacking is a process by which one renders non-comparable licenses comparable. So they say, well, look at the way he's using comparability there. The judge might equally well have said unpacking is something that enables a meaningful comparison to be done between comparables. And so for that reason we say it's not a sound point, and it didn't have anything to do with the judge's decision that he wouldn't rely on the experts, which I've gone through. So my lord, those are our points on ground 1.
In which case, shall we resume at 10 to 2?